Welcome, everyone, to this Professional Development Hour presentation brought to you proudly by the Atlanta Metro chapter of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. Before we begin, we'd like to let you know that any opinions presented tonight are solely the opinions of the presenter and not that of the Georgia Society of Professional Engineers, the National Society of Professional Engineers, or any other of its affiliates. We certainly hope you will enjoy tonight's presentation, so sit back and relax, and on with the show.
All right, everyone. Okay, ready for the presentation? Today's presentation is on 5 things that engineers should know about dispute resolution. Our presenter is Mr. Terrence Croft. He's an attorney, and he's a mediator for JAMS Atlanta. Is that correct? Okay. Before I forget, please make sure you turn off your cell phones. All right. Take it away. Thank you.
Thank you. Good evening. I'm Terrence Croft. If you can't hear me, put your hand up and I'll try and lift it up a notch. Before I start telling you about me and my company, I'd like to know a little something about you. First of all, is there anybody in this room who's a lawyer? Thank heavens.
I asked that question too.
So I can say anything I want to, and some of you may know it's wrong. Any of you been to law school, any amount of law school? This is a virgin group. That's wonderful.
Take it easy.
Is there anybody here who's ever served as an expert witness in engineering? A lot. Okay. Well, then you're going to know the problems. How about people who haven't been a witness in a deposition or a trial, but who have been a consultant to a law case, tried to help one side and hurt the other? All right, got it. You know enough to be dangerous about this business. Alternative dispute resolution is an alternative to litigation. Some people don't like the expense, the delay, the inconvenience, and the fact that it's very difficult to predict outcomes in court. Georgia, although it's #1 in the country as a good place to do business, is also known as the hellhole of litigation, because of the large number of post-COVID shock verdicts that juries have handed down. Cases that might have been won by the defense, or at least not lost for very much, are being lost for millions of dollars. Millions. One recently came back at over $1 billion for a personal injury case. So those are the real drivers. You hear a lot of talk about how judges and lawyers are really concerned about the fact that it takes way too long to get to trial. Well, that's true, it does. It shouldn't take that long. It took a long time before COVID, and because of COVID, we absolutely shut down the courthouse, and nothing got tried for a period of time. And now slowly they're beginning to reopen the courthouse for things other than criminal cases and divorce cases. So they're still getting priority over just arguments about money, which is what most litigation involves. The studies show us that of 100 filed cases in most courts, just cases of any kind, that less than 5% of them will ever go to trial. Well, what happens to them? Well, some of them, the parties give up or die or get dismissed. But basically what happens is they settle. So the clever gurus of litigation and courthouse work decided that the thing to do would be to accelerate settlements so that more cases would settle sooner. That would overcome the delay problem. It would reduce the expense problem. And if they're going to settle anyway, you don't worry about how much they're going to settle for, because nobody settles who doesn't agree to the settlement. And so, problem solved. All we got to do is get people to settle cases sooner. How do we do that? Well, judges know how. Bring in the jury. That'll cause people to pucker up. But if they couldn't bring in a jury because everybody knew they didn't have one, or if they'd shut down jury trials so everybody knew there wasn't one to be had, the money managers for the big insurance companies, anybody in here work for a big insurance company? Not anymore. Those people looked to the money, and as long as they weren't paying anything out, they were happy as larks. They had that money in their investments. Now, the investments maybe didn't work out so well. I don't know about you, but COVID didn't help me with mine. But the insurance companies were not pushing any of these changes, so other groups did. And one of them was a group of judges in California who retired and set up a company to do private judging for people. And the company was called Judicial Arbitration and Mediation Systems Services. And that company puttered along for a little while. It was 10 or 12 of them who started this thing. And it went further than that. There were some corporate buyouts and repurchases, and the company was renamed with its own acronym, JAMS, that a lot of people still relate to Judicial Arbitration and Mediation Services, but it's not. It's a new company that succeeded the older one. They also realized that judges didn't make the best business getters of all time. They maybe handle and process. They're used to thousands of cases a month being streaming into their chambers from the clerk's office and them being told to be responsible for it. So they could handle that part. But lawyers were used to putting up these stupid ads on television, one call, that's all, and the rest of that stuff. So lawyers would go out and hustle business better than judges. So they decided to find some lawyers who knew a little something about arbitration and mediation, but who were good hustlers. That's about the best you could say about me. Nobody ever said I was a terrific lawyer, but I've always been a good hustler. So the JAMS company became the leader of private for-profit ADR companies. ADR, Alternative Dispute Resolution, means mediation and arbitration, and I'll teach you the difference between that if you're not aware of it. Some of you wisely know the difference and some of you don't care, but it makes a huge difference which one it is. I'll do it in a quick summary way so you'll understand the details a little better, how they fit together. Arbitration is essentially a private court You can guess what some of the reasons are about why privacy is important. If you're litigating about the secret formula of Coca-Cola or something you think is a big important special knowledge that one or the other has. Sometimes it's two companies fighting over it, or two partners who've had a company and been successful. You know, it's funny. I've mediated 100 of these cases over the last 30 years where two partners put something together and they just fought like cats and dogs against the outside world to make a success of this business. And while they were working so hard fighting this common enemy, they got along pretty well. But when they hit the jackpot and started to do well, they began arguing between each other about who was more responsible than the other for our great success. And they killed the golden goose. And they each blamed the other. Oh, he's cheating, or he was dating the receptionist, or whatever it was. And the arguments went on, and they began fighting with each other, blaming each other for every mistake that anybody made. And the business didn't do as well as it did before when they were fighting off the hordes of attackers and criticizers that there were. That's not a point of this talk. That's not one of those 5 things you have to remember, and there's only going to be 2 that you really have to remember. Plus a third one, because I'm going to tell you a little bit about how I think you can benefit from this new wave of arbitration and mediation that's replacing the old default mechanism of, well, hell, let's call in the jury, we'll have a trial. In 5 years. What are you going to do in the meantime? Pay the lawyer. The lawyer loves that, but the client doesn't like it, and they don't benefit from it. Yeah. Is that a little better? Yeah. Okay. I'll do my best. Old age and the lack of acoustics in this particular chamber. We'll blame Steve for that. Maybe he can pick one. No, I'm fine. I've got a quart of it right here. All right, so the main difference between mediation and arbitration is a private court system that the parties control and pay for. And they can have an arbitration hearing in a conference room at JAMS or at any place else they agree on, or the arbitrator orders. The arbitrator is like a private judge. He operates under certain rules that the provider company that provides him has drawn up. And if there isn't a provider company, if it's just a lawyer who says, I'm an arbitrator, which you can do. In fact, you can do it. You don't have to be a lawyer to be an arbitrator. We'll come back to how you get to be an arbitrator, because that may be of interest to some of you. If you want to move up where you can hear better, that'd be fine too. Because there's only so much volume on my bass button here. But having a private hearing, having a private trial, having your own schedule that you work out, it's a 3-legged stool. It's the arbitrator, and if it's a 2-party case, you've got the lead counsel for each party. And all they've got to do is get their troops organized, and they can sit down together and figure out a schedule, which is about the first thing I do when I get a new arbitration assigned, is to get those lawyers together and talk to them. First of all, what's this case about? So is this a nursing home malpractice case? Is this a train wreck? I mean, I've had, and I don't limit myself unless the subject matter is so arcane, like an oil and gas dispute out of Texas. I would turn that down because I never touched anything like that in my law practice, and it would be unfair to ask the lawyers to teach me the first and second year courses in oil and gas disputes before I would be up to speed and understand what they were telling me. I'd tell them, I don't do that. And they'd say, okay, well, that's fine, we'll find someone who does. Or they would tell me, look, it's not rocket science, it's down to whether this document or this document is the one they really signed. That's what, you've decided stuff like that all the time. I said, sure, I can do that, as long as it doesn't matter that I don't understand one kind of oil well from another. The truth is, if you know the process and know how to keep it moving and keep the lawyers engaged, you can arbitrate or mediate almost anything. If you notice at the courthouse, the judge was not selected for his or her expertise in the subject matter. There are a few courts where criminal cases are sent to a particular division and different judges take a turn doing that. Other courts where family law issues predominate. And then there are some, like a probate court, which has a subject, family law type issues, wills and trusts, stuff like that. But for the most part, in a court of general jurisdiction, in the Superior Court of the county, well, we're in DeKalb right here, whatever county the judge of the Superior Court, she's got jurisdiction over any damn thing that anybody wants to bring. That doesn't mean she knows how to do it, or that she even took a course in it in law school, because they don't try and assign to judges who would be the best one in the room to take this case. But you can do that in arbitration, because the two sides can get together and pick an arbitrator that they believe is the best person to try this case, that they both know, they both respect, they both believe that they're of some significance or consequence to the legal profession and will be fair. Now, that's a neat thing, because you don't always get that in the courthouse. Once in a while you do. And often you get someone who's good at what they're doing just because they've been doing it for several years. And you know, even a blind pig can find an acorn once in a while. And so they get better than they were before they started. That's a good thing. Experience, unless your ego is so great that you won't let yourself learn from people who appear in front of you, and while they're kissing the hem of your robe and calling you Your Honor and laughing at the worst jokes you've ever heard, they're able to educate a judge how to do a better job. Well, with an arbitrator, you can get over all that. You can pick who you want for this case, who's available, whose health is reasonably predictable, not perfectly, but you know, we're all just human beings. We do the best we can. If I get bad news from a doctor, I'm going to have to tell people so they won't pick me for something that I won't be around to finish. That gets harder to do every day. Some of us know that. Some others are going to figure it out before too long. But it's nice to be able to select who you want to try your case in front of. And that's what an arbitration is, a private, adjudicatory resolution of the matter. And when the hearing is over, and you have a hearing, you have a court reporter, if you want it. If you want a case where you don't make a record, because you don't want a record, your client doesn't want testimony or certain evidence to be preserved, you can get a result where everybody just keeps their hands up and nobody makes a record of anything. Now, if one side says, well, hell, I want a record, I want to be able to appeal. Because if without a record, it's a whole lot harder to appeal, unless it's over a certain document or something that does exist. But that arbitration hearing that takes place before some one or more, it's not a good idea to have an even number because somehow they may end up not being able to agree. Now, frankly, I don't think that happens very often, but the wizards of this industry believe that it ought to be an odd number. What I have found is when you have 3 judges instead of 1 hearing the same issues and deciding the same case, it's not that you're likely to have a disagreement where it's 2 to 1 or the other way. They usually agree, but it costs 3 times as much to have them go through all the process and sit there and reach an award and send you a bill for it. Also, the scheduling. Hey, can we have a meeting next Tuesday? No, not Tuesday. I can't do that because I've got a. Well, how about Wednesday? No, I've got a problem with Wednesday. Well, how about Thursday? Well, they both have a problem on Thursday. So it's 3 times, or perhaps the algorithm is greater than that. Maybe having 3 people instead of 1 is not just 3 times as difficult, it's 10 times as difficult. I'll tell you this, it's more difficult because I've been in the middle a lot of times. And there's another problem with having, the way it comes up sometimes is you have each side under the agreement that they've reached. Each side picks somebody that they want, and those 2 pick the third. Now, that's an interesting process if you think about it for a minute. The one that you picked knows who picked him and who's paying him. The issue between the parties about who pays whom and for what will be decided later. You won't know unless it's been previously agreed to. So when those 2 sit down to pick, they're supposed to do it neutrally and fairly, but that's asking an awful lot of people who are, they have to put down the fact that they're not representing the party that selected them and is paying them. And maybe they can do that, but if I'm the middle guy, I'm the third one that they pick, when they ask me, will you do this? Are you available to do it? Can you have a conflict with these parties? I have a few questions about the case to make sure that I'm not going to be criticized for accepting that case. I would have to disclose any conflicts that I've had within a relevant period of time. And I might be challenged for cause if it turns out it was one of my former tennis partners that used to beat me like a drum, and he's in this arbitration. Becomes a problem about that, but let's assume you can get past that problem. I don't want to have a guy who's supposed to be neutral and who is supposed to be like me in deciding the case sitting beside me and actually serving as though he were a partisan lawyer for one side and against the other. It's unseemly, it's unpleasant, and other than this reason, I can't think of another reason to do it. And it took a while, but I realized that unless they would agree with me that they will put down their partisanship and that they will play like neutrals, and I can count on that. I will not have, they can argue with each other. They can disagree as much as is necessary. That's fine. That I would expect them to do that if that's what they really thought. But I would not want them to be doing it because they thought they'd been bought and paid for, because that's not the rule. Now that is the rule everywhere, and for a long time, I've been doing this long enough to watch some things change and develop, and that's one of the things that's changed. But I recommend that if you ever have a client who involves you early enough in the decision process and asks your opinion about it, you'll remember the fact that you might as well just have one, because it'll be more practical, more economical. Now, if the one goes against your side, they're going to remember who it was who said, let's just have one, and prevented having two more who might have helped. So you got to weigh that in there too when you're making that decision. But the difference then is that arbitration is adjudicatory. It is set up to resolve the dispute with an award by the arbitrator. If the parties don't just obey the award, because an arbitrator doesn't have a marshal, a bailiff, a sheriff, or a bunch of soldiers to go enforce the award, how do you get an award paid by somebody who says, I'm not paying that? You have 1 year from the date of the award, in Georgia anyway, in the Superior Court, to go take that award to the court and say, Judge, confirm this. And the other side, within 90 days of the award, so a lot of times everyone's holding their breath for the first 90 days. Within 90 days, the loser can ask that the award be vacated, thrown out, for whatever reason. But the reasons are limited. They're not like taking an appeal in a courthouse case where you have a jury and the jury renders a verdict and it's $1 million against your client, and a judge enters a judgment based on that verdict. The jury has truly rendered a verdict in the amount of $1 million. I hereby enter judgment against the defendant for $1 million payable to the plaintiff. Okay, what do you do with that? Well, reconsider. Judge, you made a mistake. You shouldn't have done this. You charged the jury incorrectly. You admitted the wrong evidence. We need to have you overturn yourself. Not likely to happen. Once in a while, maybe, but not likely. So then you appeal to a higher court, and Georgia would likely be the Court of Appeals. It could be the Supreme Court, but usually you've got to make an intermediate stop. So you've got an appeal to the court to correct the error that was made below, and they get to review the whole 9 yards. So that's not the way it works in arbitration. If you go to the court and ask them to confirm or to vacate, they have very limited bases on which they can do that. They don't have that broad, any mistake that was made that could be brought to bear on that verdict, the way you do in a court case. In arbitration, the arbitrator can be wrong as long as he isn't in bad faith. He can be wrong on the facts. He can be wrong on the law. He can't say, I know that the law says this case has to be brought within 2 years under the statute of limitations, but I think 2 years is too short, so I know it was 3 years here and I'm going to allow it. Can't do that. That's a mistake that is setting his opinion over what the law is. If he knows the law is this and he chooses that, then you can throw it out. But you can't throw it out just because he made a mistake and he got it confused. So it's extremely limited, and you say, well, why is that? And the answer is because of the way arbitration developed historically. It was developed to be a quicker, cheaper, more predictable, less subject to the delay and expense of appeals. It was supposed to be done by somebody who knows what he's doing, that the parties picked for knowing what he's doing, and they should be likely happy with what his judgment is. Some of you may recall from your readings of English history that various tradesmen, like the forerunners to engineers, had groups that they brought together. They weren't unions, they were called guilds. And various tradesmen in a particular trade belonged to the same guild. And the guilds developed a process much like the forerunner of our present-day arbitration in order to help inside their family of guild hall members disputes that they had that were of a business nature. And they thought, who better to decide this? If you have a dispute with you, why don't we take a minute and let's talk about it right here, and we'll see if we can solve the dispute among us, your friends, your fellow tradesmen, your guild hall members. So that was the way that it all began, and that worked pretty well for some of them, but it didn't do much good if you had a dispute with another guild. If you had a vendor who was supplying materials and he wasn't part of the guild that was actually fabricating things out of the materials. So anyway, there's a historical basis for it, which can be thrown out anytime somebody decides it doesn't apply anymore. But for the time being, the bottom line, the takeaway from this long bunch of talk about it is arbitrations are more likely to be final, not appealed, and not successful if they are appealed, so people learn not to waste their time and money appealing them. Now, that's not always true, and big companies where there are big bucks involved will spend the money to do it and to go ahead and take it to court, and that will drag it out and it will cost more. But the typical rule is if there's a way to sustain it, it will be sustained. So that's another thing about arbitration to keep in mind when you're selecting it. Question.
Type compensation for the arbitrator. What type of compensation?
Big as you can get. There are people who donate their services. The AAA used to ask people to give the first day free when they sent you a case. And for a long time people did it because otherwise the lady that ran the office of the AAA, who was just mean as could be, I loved her, but she was hard to get along with. Because I wouldn't give the free day. These people didn't give me a free day. Why should I give them a free day? I mean, this is not a charity, this is a business all the way around. But the AAA, which is not designed to be a for-profit, it's a non-profit organization, unlike JAMS. JAMS is a for-profit. In fact, it grossed over $200,000 last year, $200 million last year. Got to get that decimal point in the right place. It makes a big difference. 200 million. So there's money in resolution. Now there's a lot of entities that provide neutrals. JAMS does a really good job of selecting them. There's one guy, a former judge out in Napa Valley, California, who is very popular and booked up solidly as far out as the eye can see. and it doesn't make any difference what he charges. And he'll charge $10,000 or $15,000 a day. Except on Wednesday. He doesn't schedule anything for Wednesday because enough people call up with an emergency. Judge, we gotta have you, we gotta have you. Next week, we gotta get this done. So he has wonderful Wednesdays, which are $25,000 a day. Nobody's ever asked Croft to have a wonderful Monday, Tuesday, Wednesday, or Thursday, or Friday. I've done some Saturdays and Sundays for a special rate for some doctors who thought they were too important to cancel out their surgeries or their office practice. But anyway, Wonderful Wednesdays comes to mind, and that's an extreme. In Atlanta, I would say the highest one I know is a former judge who charges $10,000 a day for serving as a neutral on an ADR panel. And there are some people who still give it away or charge little or nothing, particularly if they're getting started. But the going rate is between a couple hundred and 1,000 a day, depending on who you're talking to. And by the way, questions are welcome at any time. I want to tell you just a little bit about mediation. Mediation is different. It is not adjudicatory. It is not the mediator's job to tell these people what to do, and you have no mechanism to make them do anything. And if you overstate an opinion too soon in the day, and they think you're not going to agree with them or listen to them, they'll just get up and leave. So there's a lot of reasons to keep your mouth shut, keep your opinions to yourself. They didn't hire you to do that. They hired you like a playground monitor. You don't even get to decide what sport the kids are playing. You just have to make sure they don't kill each other. And that's sort of what a mediator does. A mediator is there to oversee and help the parties reach an agreement, a settlement. That's what they come to the mediator for. Please sit down and listen to us and help us listen to each other and help us negotiate to settle the case. So a successful mediation, in the simplest terms, results in a settlement. It's written out. Sometimes I've been there at 1 in the morning as they negotiated punctuation, and they had dueling laptops sending drafts of the settlement, because a settlement agreement could be a very important document. This is going to be the basis that they're going to stop the lawsuit. Now, you can do a mediation at any time. You can do it in the middle of a trial at night. I've done that. The judge says, you folks need to settle this case. And they say, well, why? I'm going to win. The other says, no, I'm going to win. Judge said, see, that's why. Because both of you are not going to win. Well, Judge, who's going to win? I'm not going to say that, and I'm certainly not going to say it with that court reporter taking down everything. But what I'm telling you is, both you guys are wrong. You're too high and you're too low. Get in there and get this case settled. Well, we mediated with Croft and he couldn't settle it. Well, maybe not. But sometimes you try in the middle of a trial. Sometimes you try Friday night before a Monday morning beginning of a trial. Sometimes you try before a suit is even filed, where the parties are negotiating with each other. Everybody's lawyered up and they're sending ugly messages back and forth to each other, ugly emails. And what you're doing, what you're there for, is to try and get some of the emotion out of the discussion, figure out why if they mediated before, why they didn't settle it, what went wrong, who was too high, what key facts were being overlooked, or what rules of law are being misapplied so that they have such a big difference that it's important to finish this expensive preparation. I mean, some of these people spend millions, literally millions, on the cost of litigation. Now, to some of you, that's good news, because if you're part of what they're spending it on, that's a good thing. For those of you who have been experts, for those of you who have been consultants who've been hired to counsel with the lawyer to teach him where the holes in the floor are so he doesn't fall through unwittingly, that's hard because the lawyer won't admit that he's not smarter than everybody in the room, and he's not. He didn't get picked for smarts. Those people went to Harvard Med School. He got picked for some other abilities, some tenacity perhaps, some showmanship, some charisma. A lot of those Harvard Med School guys are pretty low on charisma. I had 3 college roommates who went to Harvard Medical School. So those guys were really smart, but not one of them, well, one had plenty of charisma, but the other 2 were very ordinary as far as that went. Anyway, mediation has room for experts the same way that arbitration does, and arbitration does the same way that litigation does. So if you've never been employed to assist a party in a mediation or a case that goes to mediation, you need to think about what you can do for them. How can you help them? How can you help them prepare? Whether they're going to do a hot tubbing of experts where both sides experts have a discussion together and everybody else just listens, which I think is an amazing concept, but I know how few of you majored in psychology or some other soft, silly science. And so I know that's not what you were educated for. You may, by personality and force of nature, you may have skills of persuasion, of discussion, of improvisation, of oral performance, and you may not. But it's become the new thing for each side to suggest putting the experts together and let them debate, sometimes in private, and then come in and announce to everybody what they've agreed to recommend to both sides, which is an interesting concept, to let your expert do that. I wouldn't unless I thought he was a lot better than the expert on the other side. If he was, I'd let him take a shot at it and see if he could do it. But I know that engineers have often helped lawyers representing parties by teaching them what the weaknesses in their position are and the strengths and how to bolster one and cover up the other to the extent possible. You don't have to be the star witness at the trial to be a valuable member of the team who bills a bunch of hours studying stuff, reaching opinions, conferring with counsel and clients to help them prepare to testify themselves. So there's room, and that can be done. I have conducted many mediations where people have brought their experts to the mediation and had them have a discrete subject matter that they're supposed to present on, which is within their sphere of knowledge, so they'll be qualified to give an opinion on it. And you know, sometimes applesauce is like peanut butter. I don't know, but if you can get paid a lot to do it. There must be another question in here someplace.
What do you do mostly, arbitration or mediation?
The last post-COVID, I used to do, when I started, it was all mediation. And gradually I got asked to do some arbitrations, which are easier for me, and I enjoy it because I know I don't have to persuade anybody of anything. I just have to figure out what's right and tell them to do it and write it down in a way that's clear so that it'll pass muster and be confirmed if necessary. And that feels good, is easier than putting up with people. It's sort of like being a divorce lawyer. I had a chance to do that when I was brand new, which was many years ago, 57 years ago. I've been doing this a long time. But having a chance to counsel with people and to work with them, which I've done 4,000 times, has been a lot of fun. But I do about 60% arbitrations today. That's post-COVID. I got really cranked up in arbitration during COVID because the courthouse was just slammed shut. There was no place else for people to go. And some of them, especially the insurance companies, don't want to arbitrate unless there's a stick poking them in the rear end. And when the courthouse was shut, there wasn't much of a stick. There was a carrot maybe to get cases settled, but they don't care about that.
One question. Actually,
Sure.
admonition. The expert has to be prepared to be in a regular courtroom, though, and they have to know the rules of law pertaining to experts in the courtroom. And it's easy to be, like you say, in arbitration or mediation, be an expert, but it's a lot tougher in the courtroom.
Yes, it is. There are a lot of technical rules about whether you'll be allowed to give that opinion or not. Daubert is the name of the principle that's applied to keep people from testifying, but
Is there a rule of thumb?
Wait,
Is there a rule of thumb how much quicker arbitration and mediation is compared to the full litigation or cost?
well, I'm available before the end of the month to give you a hearing on your case if you want it,
Okay. That quick.
and we can do it. Now, usually it takes about 6 to 9 months for most lawyers to be comfortable because they want to prepare their case the same way they would for the jury trial. They just won't have a jury. They'll just have me that they're pitching to, so they can base their presentation on what they think will be effective with that trier of fact rather than the geese in the jury box. I think I've killed your hour. I hope you get credit for this. I've enjoyed looking at you.
thank you.
If anybody cares to have a handout about jams, I'll put it over here by the door.
Yeah, we'll put those right there on the desk.
Yeah.
Thank you. And Terrence, if you would accept this small token of our appreciation for sharing your knowledge here with us, really appreciate it.
I'll try not to commit malpractice in the use of it.
Folks, we have the door price. And do you have the list of the sign-in sheet? Okay. How many? Okay. You tell me how many, and I'll generate a random number.
Series of books to choose from. And by the random number generator, somebody will come away with their choice of several valuable books. These are books that have been proven. They've been read by somebody.
But they're used books.
They've been proved.
And you get your choice.
So, Lucci, you won last month. did you not?
I did.
How did you like the book you got?
I'm still working on it.
And what was the title?
Selling,
How to write copy that sells?
yeah.
Phil, you got a, no, well, he got the previous month. I don't know. You got, bow, kiss, or shake hands. Overseas, business etiquette.
Okay, so, these are the books we have. Megatrends, older book.
Published 1982. The guy who was predicting the future. Anybody want to see if he did it right?
This is my favorite, Attitude is Everything by Keith Carroll. I actually heard him speak a number of years ago, and he was so wonderful, I ended up buying his cassette and listening to it.
We hope you enjoyed this presentation given at one of the Atlanta Metro Chapter meetings of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. To find out more about us or to join us, check us out at gspe.org.